Right, I'd like to welcome back to the podium Mohammed Salaji, who's a tax director, and Leslie Isherwood, an associate tax director from KPMG. They were both introduced to you at an earlier session this morning where they presented in SARS information gathering powers. So I'm not going to go through their respective CVs and qualifications. However, you'll notice that I managed to obtain some personal information on the previous two speakers, and Mohammed and Leslie, you two are not exempt from that, although it was much more difficult to obtain information from your colleagues. Some of you might not know about Leslie is she had a choice between a sports car or her two dogs, and her two dogs won. As far as Mohammed is concerned, the only information I could get from some of his fellow partners was that he didn't undertake any personal tax planning in Saudi Arabia during his 3.5 years there. Right, I'll hand over to them. Thank you.
Thank you very much, Ray. Can everybody hear me? I know the earlier session some people said they couldn't hear me, so please just stick your hand up if you can't. Firstly, I take my hat off to all of you. I do admire your perseverance. I know yesterday people were complaining. I think it was one of the late speakers that was saying that this is the graveyard shift, and then Andrew mentioned that again. But guys, who are they kidding? This is the graveyard shift. We can clearly see it. So what we're going to be trying to cover, hopefully quite quickly, and within the time, I assure you, is the question of confidentiality of information. It's dealt with quite neatly under a completely new chapter under the Tax Administration Act. But a few sort of opening comments that I think are certainly worth making on the particular topic. I think if we sit back and look at why is confidentiality or secrecy important, it is clearly key to effective tax administration. Taxpayers really have a right to expect that the information that they're going to be providing to SARS will be kept confidential. And that confidentiality clearly encourages proper and full disclosure by the taxpayer. So if we look at what was the position quickly prior to the Tax Administration Act, I think one can broadly categorize it under a few sort of points. Let's first look at some of some of these provisions were certainly contained in specific sections of the Income Tax Act, specifically, for example, Section 4 and Section 6 of the VAT Act. And if you look at some of those sections, they broadly look at this concept of taxpayer information as we have it currently in the Act. So it really covered a lot of those areas which related to information which is very germane to the taxpayer, and didn't really cover extensively enough the so-called SARS confidential information. Then, if we also look at the position before this, being both the information that is so-called SARS information and information which is taxpayer information, one has to again look at the Constitution and, in this case, also the Promotion of Access to Information Act. And I know we've spoken quite a lot over the past 3 days on some of the provisions of the Constitution, but I do think, and if you will indulge me, that it's important, just in the context of confidentiality of information, to maybe reflect on some of those provisions, because it does give some context to what hopefully we'll talk about as we go through the presentation. So let me start by looking at Section 14 of the Constitution, which obviously forms part of our Bill of Rights. That's the privacy provisions, and I'm going to just talk through what those are. It says everyone has the right to privacy, which includes the right not to have, number one, their person or home searched, their property searched, their possessions seized, and probably more importantly for the purpose of this discussion, the privacy of their communications infringed. So you'll see that we've covered a lot of those other areas in the various topics. The one that requires some focus is privacy of communications between an individual and the state, and clearly information that is transmitted between a taxpayer and SARS falls squarely within that. We then have to look at also Section 32 of the Constitution, which deals with access of information. So this is in circumstances where obviously individuals, taxpayers, want to get the state to disclose certain information. And that provision under Section 32 says as follows: everyone has a right of access to any information held by the state and any information that is held by another person and that is required for exercise of protection of any rights. So again, I think what we're saying here is that you've got clearly constitutional provisions that deal with both the protection of information on the one hand and the rights to access information that the state holds on the other. Section 32 does talk about legislation which would have to be passed, and that, as we know, was done under the PIA in this particular context. And I want to specifically refer then to Section 35 of PIA, which deals specifically with mandatory protection of records for SARS purposes. So Section 35 of PIA reads as follows, subparagraph 1, subject to subsection 2, the information officer of the South African Revenue Service must refuse a request for access to a record of that service if it contains information which was obtained or is held by that service for the purpose of enforcing legislation concerning the collection of revenue as defined in Section 1 of the SARS Act. And if you go to obviously Section 1 of the SARS Act, it really lists the various pieces of legislation that's governed by SARS. Subparagraph 2 then says a record may not be refused in terms of subsection 1 insofar as it consists of information about the requester or the person on whose behalf that request is made. So again, giving an exception to the one who's actually asking that information from SARS for him to get access to that information. But it really deals with two key principles here. One is clearly the secrecy provisions that is now entrenched under PIA, as well as the right of an individual to access his own information. And I think that hopefully sets the scene for the topic that we're going to talk about, which then brings us on to the provisions of the Tax Administration Act. And what we really can maybe surmise is that the confidentiality and secrecy provisions under the Tax Administration Act are really sought to be codified under Chapter 6. I say sought to be codified. We'll get on to why that choice of language. But by really incorporating these two principles, the SARS information or SARS confidential information on the one hand, as well as now revising the taxpayer information on the other. So, in essence, what we're saying is that the information flow that is now sought to be covered by the Tax Administration Act is sort of diagrammatically illustrated below. You'll see that the information flow between SARS and its information, SARS confidential information, that one can almost ring fence in many ways. And you've got the taxpayer information, which is information germane to the taxpayer. And the information flow typically happens from taxpayers to SARS. That's the main stream of flow of information that would typically arise, and this is what the legislation seeks to really deal with. There would be an exception when you find that taxpayers would have access to information which is typically SARS confidential information. But for the main, that's really how the information flow would typically work.
Okay, I'm going to have a quick look at what the Tax Administration Act regards as SARS confidential information. Now, basically it covers various categories: personal information about current or former SARS officials, information which is subject to legal privilege vested in SARS, information supplied in confidence by third parties which would be prejudiced if disclosure was made about that information, Information related to the investigation under Section 39 of the Promotion of Access to Information Act, and this deals with mandatory protection of police dockets and bail proceedings and protection of law enforcement and legal proceedings, so very specific. But then SARS operational information is also protected. That would include any opinions that they've obtained on particular issues, any advice that they've sought, if they've obtained it for purposes of assisting in formulating a policy or in order to take a decision or exercise any of their powers. That would also be SARS confidential information, and the disclosure of that information could be expected to frustrate whatever process it is that SARS is following, or the success of any policy that they're trying to implement. So those are some of the examples. If SARS is carrying out any research, the disclosure of which could prejudice the outcome of that research, if they're looking into changing tax rates or introducing new provisions, taxpayers, if they get wind of it, may act contrary to what the objective of a particular issue is. That information would also be confidential. Disclosure of information which could prejudice the economic interests or welfare of the Republic or gain the ability of the government to manage the economy, and that includes any decisions to change any taxes or levies. Any computer programs owned by SARS, information relating to security of SARS buildings, structures or systems. That's quite straightforward. Information supplied in confidence by or behalf of another state or international organization to SARS. There was a discussion around that in our earlier session in response to the question about the South African Reserve Bank, how information is that the Reserve Bank shares with SARS is regarded as SARS confidential information. And just 2 points to actually note, that the duty not to disclose falls on current as well as former SARS employees. So don't believe that if you leave the employment of SARS that the person would no longer be bound by the confidentiality provisions. They are. But the onus on claiming that information is confidential rests on SARS. So they would need to invoke and prove that the information is confidential before it actually gets protected by this section. Some of the questions that we've been grappling with is, we spoke earlier on in the information gathering space about selection for audit and verification and inspection, and one of the bases on which you can be selected is risk assessment. And the question that we've been asking ourselves is, if you are selected, are you entitled to actually ask SARS for details as to that risk assessment and to have sight of the indicators or the factors that ended up having you being flagged as a high risk or somebody that they wanted to actually have a look at? Or would would SARS been able to deny that request on the basis that it is SARS confidential information? We expect that SARS probably would claim it as SARS confidential information, but we're interested to hear if anybody's got any thoughts on that.
Just got a sort of letter from SARS to say that a certain amount that was declared is actually reserved.
We must explain that because it differs from the information in the financial statements or something ludicrous like that. And then we requested the document that they're referring to, because we didn't know what document they're referring to that we submitted to SARB. And they said, but we can't get that document. But they couldn't tell us in what report was it. So my opinion was just that then you're just leaving it right there, because how can they say that we found this document that does not tie up to your financials, and nobody knows about a document that has been submitted?
I think there's a clear provision in the Act, not just obviously, as I said, under PIA, but even in terms of the TAA, that would allow you to request that information, because that is your information, which would not typically fall under the confidentiality provision. So I can't see any difficulty in requesting that information, both either under the TAA or specifically under PIA. And under PIA, there's obviously a procedure that you need to follow, but certainly I would consider going that route, because you are obviously being prejudiced by virtue of a document that you're not aware of on which you are being taxed on.
Related to this, at one stage, SARS were going through a risk profiling exercise. I don't know if you remember that in the days of Joseph Rock at the LBC. And I had various meetings and discussions, and we said, well, we might like to be classified as low risk. We have the governance procedures, the expertise, etc. in place. And at that point in time, the view was, and they told us, because of the number of offshore transactions you conduct, you'll automatically be qualified as high risk. So in those days, they gave that sort of information. Whether their view would now change in terms of the Tax Administration Act, and whether that would be deemed to be confidential information, I'm not sure. Okay.
All right, if we can then maybe move on to the concept of taxpayer information. We've discussed very broadly what SARS confidential information is per the Act. Let's look at what is the concept of taxpayer information as per the Act. And I think one can't actually do that without first looking at what was that definition in some of the previous acts. So I've limited it just to the Income Tax Act. The old Section 4 was certainly, in my own mind, fairly more generic than what we currently have. And if you look at what it said every person employed by the Commissioner in carrying out the provisions of this Act, i.e. the Income Tax Act, shall preserve and aid in preserving secrecy with regards to all matters that may come to his or her knowledge in the performance of his or her duties in connection with these provisions. So there's clearly a clear link between the information that was gathered by SARS and SARS officials and the discharging of their duties and in getting that information. I think if one looks at that quite cold, one might say that as much as it's broad, it's not as wide as what we have under Section 67 of the Tax Administration Act. And if we go to Section 67 then of the TAA, it does define taxpayer information specifically as any information provided by a taxpayer or obtained by SARS in respect of the taxpayer, including biometric information. So in my own mind, it's certainly a much wider concept of what is taxpayer information. And obviously this is a good thing, because this is the protection. This is the protection we're looking for, that taxpayers are looking for. And the key issue here is that that information may have been provided to SARS, arguably not even in the course of their duties. It would still certainly form part of the secrecy provisions. The interesting observation that we need to pick up on is that one can see that this definition of taxpayer information, when you compare that to SARS confidential information, which Leslie just spoke about and talked us through, this is very it's very wide, because it deals with any information, whereas the SARS confidential information is very specific. It was listed in terms of what that information would be, and one can see here what obviously the legislature has been trying to do, and that is to strike that balance between making sure that taxpayers' rights here, on the one hand, are kept as broad as possible to protect the taxpayer, but at the same time ensuring that taxpayers who seek information from SARS, defining very specifically then in that instance what is SARS confidential information. So because of the very wide import of the definition of taxpayer information, I think it might be useful just to quickly run through what information would typically be within the, would typically come to SARS, or would typically be transmitted to SARS in terms of the various communications that taxpayers would have with SARS. taxpayers' personal information or company registration details, which are disclosed to SARS via tax registration, would certainly be taxpayer information. Biometric information is certainly a fairly new concept. It includes biological data used to authenticate the identity of a natural person by means of facial recognition, fingerprint recognition, voice recognition, iris or retina recognition, and an interestingly less obtrusive biological data would also be used. So there's a catch-all broader phrase, but clearly moving into a more scientific, more technology-based era of identifying individual persons. We then look at information which obviously is obtained from returns, from PAYE, VAT returns, etc. Those would be information which clearly would be covered under the confidentiality provisions. Information obtained through requests, audits, inspections, inquiries, information presented in person, etc., etc. All certainly would fall part of the confidentiality. And interestingly, this certainly goes in our minds wider than the question of relevant material, which, as you recall, we spoke about that quite extensively when we discussed the SARS information gathering powers, because that was very specific to the administration of the Act. This is much wider than that. And then obviously information, arrived through any other means, VDPs, reportable ranges, etc. So all of that information that you then transmit as a taxpayer to SARS certainly would, in our mind, form part of the secrecy provisions. I think the important point here, if you look at just the kind of information that would be transmitted, is that SARS does have access to a lot of know-how, trade secrets, business strategy, customer lists, contracts, and leaking of that kind of information can be damaging. And that's really the whole purpose of the secrecy provisions, is to get that information to be leaked to the broader public, to your competitors, or to anybody that might be able to use or abuse that in the wrong way. Who's bound by this? It's certainly the current or former SARS officials must preserve that secrecy and that information, may not disclose this to sort of any person, and is bound by oath. So there's clearly, again, an oath that needs to be taken, and a breach of that oath is potentially a criminal act. Talking about that, then the question really is what rights do taxpayers have if there is a breach of confidential taxpayer information? And again, if one sits back and looks at the extent of information that typically SARS would have, breaches could happen in sort of various forms. I think the one that we certainly spoke about over the past 2 days is the information that seemingly gets into the hands of journalists on these inquiries, and certainly those would still be regarded as confidential information. Question is, how is that information leaked to the journalists is really the debate. So under Section 236, which is the sort of sanctioning provision, it does say that a person who contravenes the secrecy provisions is guilty of an offence subject to imprisonment for a period not exceeding 2 years. And this cuts both ways. So if, for example, a taxpayer were to come in hand with information which is SARS confidential information and were to go and publicly disclose this without the necessary consents, then that would apply just as much as if, for example, SARS official were to disclose information which is of a taxpayer information nature and subject to the secrecy provisions. I think certainly in my mind it also goes wider than just a person. It goes wider than just the taxpayer or SARS. By reference to person, there certainly seems to be a notion that even if information is received by a third party and the third party were to pass that information on, that information should still be treated in confidence. So let's use the example again of, for example, a journalist. If a journalist, for example, has obtained information from a SARS official, the Tax Administration Act now says that that person who receives that information is also bound by the confidentiality provisions. So the question whether a journalist may, for example, go and extend by going and publishing information which would otherwise be secret could also potentially fall under Section 236. Again, because not only of the use of the word person under 236, but again, also because of the very fact that Section 60, I think that Section 67, subparagraph 3, clearly passes on the confidentiality to third persons. I'll read that for you. It says, in the event of the disclosure of SARS confidential information or taxpayer information, contrary to this chapter, the person to whom it was so to disclose may not in any manner disclose, publish, or make it known to any other person who is not a SARS official. Okay. So quite clear that it's wider than just the taxpayer and SARS. I guess if one talks about, well, what other recourse does, for example, taxpayers have in this instance where there has been a breach of the secrecy provisions, apart from the criminal sanctions, there has obviously been some suggestion that SARS officials could, for example, be liable in their personal capacity, bearing in mind that they have taken an oath not to disclose the information. But what if, for example, the situation were to arise where the information were to be leaked which causes actual financial and pecuniary damage to a taxpayer? Could one, for example, invoke delictual claims arising from such action? Certainly, I'm not going to profess to have a view on this, but it's certainly a thought that does come mind in the context of the new provisions.
Okay. I think that we now sort of have a sense of what SARS confidential information is and what taxpayer confidential information is. But this information can be disclosed in certain circumstances, and really there's instances where the disclosure is driven by SARS and instances where the disclosure is at the behest of the taxpayer themselves. And if we start off and we look at instances where SARS can disclose taxpayer information, I'm not going to go into all of the detail around this. The sections, at Section 70 of the Tax Administration Act is quite dry, but just to give you a flavour of some of the instances. SARS can obviously disclose confidential information to the South African Police as well as the National Prosecuting Authority if a tax offence has been committed. SARS is also entitled to disclose information if it's a matter of if there's an imminent danger to public safety or in respect of environmental matters. They're entitled to disclose confidential information to the relevant parties. If a SARS official is called as a witness in either civil or criminal proceedings, clearly they may, in the course of actually giving evidence, disclose confidential information. That's permitted. If there's a High Court order compelling them to, that would also be a clear instance of where they are required, or if they're required also to disclose under any other act, that would be a further instance. Now, if the information is public, that would be quite clear. And then there's certain permitted exchange of information between various government agencies, so the Reserve Bank, National Treasury, the Statistician General, and a couple of other government or quasi-government functions that where the exchange of information is necessary for the fulfillment of the powers and duties of those various departments within government. They can share information. A taxpayer, the other instance where SARS is entitled to disclose information is if you as a taxpayer basically enter into a public spat with SARS, and as you go into the media and you release false allegations or false information, SARS is able to release confidential information in order to refute those allegations. So we've seen a bit of that going on in the media as well. I think that when it comes to SARS information or SARS confidential information, or even taxpayer confidential information, one of the most concerning things that we've seen is in relation to the appointment of sort of third parties as agents for the collection of debt by the part of SARS. Now, that would be a unilateral, in certain instances, action by SARS where they send either a bank or an employer, or in certain instances a contracting party that a taxpayer is contracting with, a letter basically saying the taxpayer owes us X million rand, we know that you are going to pay the taxpayer in the future, or that there's money in their bank account, that there's money payable in terms of this contract or in terms of their salary. We want you must pay that amount of money over to us in settlement of the taxpayer's tax debts. And PS, at the bottom of the letter, you may not tell the taxpayer about this letter. You've now got a third party that SARS is attempting to actually be held bound by the secrecy provisions in the Act. But that third party hasn't entered into any formal engagement with SARS. They haven't been entered into any contractual arrangements in terms of which SARS has appointed them with the agent. It's literally a question of SARS just sending a third party letter and saying, pay the money over to us. And in order for a person to be bound by the SARS confidentiality provisions, that person needs to be a SARS official as defined under the Tax Administration Act. So from our reading of it, there's no mechanism in the Tax Administration Act which enables SARS to actually hold that third party bound by the confidentiality provisions, and that there's nothing in the Tax Administration Act that would preclude that third party from actually notifying their client or their contracting party of the letter. The caveat to that, though, however, is we've spoken over the course of it's come up a couple of times in the course of the last couple of days, that third parties can in certain instances be held liable for the debts of taxpayers, and one of those instances is where you knowingly assist the taxpayer in the dissipation of assets. So if you are going to contract with a particular taxpayer, you owe them a certain amount of money, you notify them of the SARS letter, and they change the banking account into which it was payable, or they change something in the arrangement, so that you're no longer, basically, either you no longer receive the money or you're no longer in a position to actually pay the money over to SARS. Have you then knowingly become party to the dissipation of the assets, in which case you could be held personally liable for the taxpayer's debt. So SARS is really putting third parties in an untenable situation where they are stuck between potentially being held liable and, on the other hand, seriously damaging their relationship with their customers or suppliers or other employees, or depending on the circumstances, who the taxpayer actually is. So in terms of looking for guidance as to where to go, one would certainly have to look broader than the Tax Administration Act to see if there's anything else in administrative or constitutional law that would enable SARS to actually hold that third party liable.
If I can just make one point here from practical experience, I agree. I don't think you can hold that third party or your supplier liable on the confidential information. I mean, if you have to withhold from a payment to a service supplier, you're opening up yourself to potential legal action, etc. Just take an example. It could be the security firm providing services at a national strategic key point. Next thing is no security, just walk out. So there are issues there. Having said that, again, practical experience, if you do advise a third party, they sort it out quickly. They want their money, so they will go and they will sort it out, whether it's with a call center, their assessor, etc. And I think that's when sometimes the gulf between the theory and the law and the practice, sometimes it works.
Okay.
As a bank, sometimes request a copy of an agreement or a copy of a contract because they
auditing the taxpayer and some other transaction. So they request a third-party information that you have. And then at the bottom of the letters, but there's no reference to any section of the Act, they would say you cannot let the client know that we requested this information. Now that puts a bank in quite a difficult position because, sometimes it's big corporate clients and you can't tell them or not tell them that you provided certain information to SARS. Is there something in the Tax Administration Act that actually actually substantiate that request from SARS?
It would again be the same. They're entitled to request the information under the third-party returns or third-party information section, but the problem is the fact that you're not allowed to notify your client of the letter. That's where they seem to be holding you as a third party bound by secrecy provisions in the Act, which you're not bound by. As I mentioned earlier on, there are instances where the disclosure of confidential information can be driven by the taxpayer, and the taxpayer can request that SARS disclose confidential information if the information is already public. If the Commissioner actually authorises that information to be disclosed, obviously if disclosure is authorised under some other Act, then the other Act would override the secrecy provisions in the Tax Administration Act. If access is being granted to that information in terms of PIA, which Mohammed has spoken about, or again if a High Court orders that information is released. Those are the circumstances under which the taxpayer can compel SARS to release confidential information.
All right, very interestingly, under Chapter 6, we also have two other sections. The one is self-incrimination, and the other one is publication of names of offenders. Let's look at just self-incrimination. It says a taxpayer, and this is governed under Section 72. A taxpayer may not refuse to comply with his or her obligations to complete and file a return or an application on the grounds that doing so might incriminate him or her, and an admission by the taxpayer containing a return, application, or other documents submitted to SARS is admissible in criminal proceedings against the taxpayer for a tax offence unless a competent court directs otherwise. So clearly here there's a very clear statement in the legislation that says that submit the information, and if it incriminates you, well, we will use that against you. There has been obviously some questions around whether in doing so, would that be a breach of, for example, Section 35 of the Constitution, which does require that every person has got a right to a fair trial, including the right not to be compelled to self-incriminating evidence. I think my own view is that we've seen this in many, many jurisdictions, and this is something that certainly is not uncommon. And certainly if somebody is going to be brave enough to try and challenge this, I think there's going to be quite an uphill battle, because there would be good grounds for the limitation provisions under Section 36 to apply here. Getting the information, as basic as the tax return, is quite critical in obviously administering tax affairs, and what you disclose there is fundamental. If you are doing something which is going to incriminate you, then I think that's what the position is going to be. So I think it will be a very brave person who's going to try and challenge that constitutionally. The other interesting section then, which has also been mentioned in the past, is publication of names of offenders. So it's your name and sort of name and shame type provision. SARS may publish for general information the following information in respect of a taxpayer who has been convicted of a tax offence. So clearly there has to be a conviction first. So we're now saying that this is now stepping outside of the bounds of the confidentiality, and there's a reason why we're doing this. And what can SARS publish? The name and the name and area of residence of the offender, the particulars of the offence that SARS thinks fit, and the particulars of the fine or the sentence which has been imposed. Again, fairly common feature in many other jurisdictions, and I doubt whether anybody would be brave enough to try and argue that this is unconstitutional. So some concluding remarks. I think what we have tried to sort of demonstrate is that the Tax Admin Act currently tries to really codify the concept of confidentiality and privacy and the privacy provisions by bringing them under one chapter of the Tax Administration Act and bringing the two concepts together. That is, again, the concept on the one end of taxpayer information and SARS confidential information on the other. However, this sort of the right to, there's not an exclusion of any other rights that taxpayers have to privacy and to access of information. So again, be guided by not just the strict provisions of the Tax Administration Act, but certainly look beyond that where this is an issue. We have seen that SARS confidential information has been purposefully defined very narrowly to strike that balance between what taxpayers can get against a more wider definition of taxpayers' information, largely to try and protect taxpayers, and certainly that would seem to be a fairly welcomed approach. The question is, has a good balance been struck between the two, which is what I think the purpose of the Tax Administration Act is, in particular in terms of this section, and I guess the jury is really out on that. So with that sort of last sort of comment, which is food for thought, we come to the end of this session and we open the floor for any other questions before we close the session.
One of the concerns involved in this technology, some of them seem to have for that. It's like, especially like for the cash flow management, it's not to ask the questions just before we start something that public information and that public information can't do. There's nothing in that source of information like that about shares and stuff like that in the market. Using that information. It's not being put that with your health and using it as well as the market. And that doesn't know where that information in SARS goes.
Well, I think that if there's that kind of example, I cannot see how that is not a breach of the secrecy provisions, because that is clearly an instance where there's taxpayer information which is being transmitted to a SARS official. That falls within the definition of any information, and if the SARS official were to use that for his own personal gain, then I would think that that's a clear breach of the provisions of the Act. And the sanctions that could apply could obviously be criminal sanction, as well as possible pecuniary sanction in that instance.
I think it's just going to be your burden of proof, your onus of proof to be able to prove that is going to be extremely difficult.
Is it not possible in those circumstances to actually request an extension to submit the information until the closed period is over?
Normally, try and keep that information until the last second. But it should be a general question. I'm pretty sure some of the other listed groups also have the same type of question, saying, well, what if somebody starts using this information in this period before we might warn shareholders of profits is up or down?
I'm certainly aware of some listed companies that are receiving those requests for information during closed periods. That the SARS is, I don't think you're an isolated instance.
Yeah, whether that gives it or the necessity for an added degree of protection, I think that's the debate.
Absolutely. Whether
if you've got your confidential information provisions, their argument is going to be it's covered by that. I mean, the fact that it's in a closed period doesn't make it any different. Any other questions before we close? All right, maybe just a few concluding remarks. We're dealing with an act here, Tax Administration Act. There are going to be interpretation issues. For me, the critical question is, how are they going to be settled? Are we going to see interpretation notes? Are we going to see some binding private rulings, binding public rulings? Again, a lot of our legal friends have spoken about litigation, brave enough to go there. And you're brave enough to go there not only because you've got to pay a lot of money, but if you're going to get Judge Dennis Davis, then you might have a chance, with respect. So there's always that issues. There's no guarantees, and so I think litigation should be avoided as far as possible. Despite the fact that you've got an Administration Act here, don't underestimate the financial consequences of not getting the provisions correct. It does have financial consequences. Everyone has mentioned that SARS has wide powers and the jury is out on whether you struck a balance or not. Sure, there are provisions in the Act as to what SARS can do. I think it's important as to what will happen in practice. What we've seen is the difficulty arises in the little communication between the various SARS offices, whether it's the LBC or the branch office or legal. And most of the problems arise from a lack of communication at that level. I think it's also incumbent on corporate taxpayers to take the initiative. Liaise with your body if you have one. Liaise with your tax relationship manager. Speak to your peers and other corporates. Benefit from their experience if you can. And right up front as a corporate, I think, decide what attitude you're going to adopt. Sometimes, I think, in my view, being pragmatic within the confines of the law, obviously, reaps more benefits than trying to be legally obstructive merely because you believe that there is non-compliance with the provision of an administrative act. So just try and get that internal balance within your respective organizations. There are times when you need to pursue it, and there are times where maybe you don't need to pursue the principle. But on that note, I'd like to thank you all for staying until the bitter end. I hope the session has proved useful, and enjoy your weekends. Thank you very much.
Thanks.
Thanks, guys.
Thank you.